Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Laquan Lewis, decided May 20, 2025. Rivera, J. A defendant has a constitutional right to proceed pro se, CCPL 170.10, 6, 180.10, 5, 210.15, 5, codifying a defendant's constitutional right to self-representation. Defendant invoked that right when he informed Supreme Court that he would like to represent himself at his upcoming trial. People v. McIntyre and its progeny required that the court make a searching inquiry into defendant's unequivocal and timely request to proceed pro se, to determine whether that request was knowing, voluntary, and intelligent. Contrary to that rule, the court immediately denied defendant's request without inquiry, and it expressly refused to consider any further request until the day of trial. The court's failure to inquire into defendant's request violated his constitutional right to self-representation. Therefore, we reverse and grant defendant a new trial. 1. In the months leading up to his trial on charges of attempted murder, robbery, assault, and obstruction of governmental administration, defendant Laquan Lewis informed the court of his dissatisfaction with appointed counsel. Defendant also filed various pro se motions, including a writ of habeas corpus, a request for dismissal of the indictment on speedy trial grounds, and at least one time, a request for new appointed counsel. Eventually, defendant's dissatisfaction with appointed counsel reached the point where he asserted to the court that he preferred to represent himself. On June 4, 2018, the parties appeared for trial. Before jury selection, defendant made an application for defense counsel to be relieved due to a conflict of interest. The court rejected defendant's claim, and the case proceeded to jury selection. After the court dismissed the prospective jurors for the day, defendant spoke on the record again. He complained that defense counsel had not provided him with discovery, including the complainant's medical records, that he needed to prepare for trial. The court responded that defense counsel would provide him with the requested discovery. Before defendant could speak further, the court stated that it would only hear from defense counsel. This colloquy followed. The defendant, I'm going to go co-counsel. The court, I can't hear you. The defendant, co-counsel. I'm going to go co-counsel. The court, co-counsel? The defendant, yes. The court, what is that? The defendant, meaning I'm going to represent myself in this case. The court, you mean pro se. The defendant, yes. I will be going pro se at trial. I will be representing myself acting as my own. The court, you made no application before me. The defendant, I never said I wanted a trial by jurors. I never told this individual that I wanted a trial by jurors. The court, you know, Mr. Lewis, I'm assuming now you're trying to play games with this court. I'll continue with this trial. If you want to speak to defense counsel about certain issues, I'll hear defense counsel tomorrow morning. The following morning, the court invited defendant to raise any issues before proceeding with jury selection. Defendant asserted again that he did not want defense counsel to represent him, alleging that counsel was ineffective, had a conflict of interest, and was not working on his behalf. The court only responded, "Okay. Nicely done," and continued the proceeding. Later that day, the prosecution extended a recommendation that defendant plead guilty to the indictment in exchange for a sentence of 16 years incarceration and 5 years post-release supervision. This recommendation was based on an assumption by the prosecution, defense counsel, and the court that if defendant were convicted at trial, he would face a potential life sentence as a persistent felony offender, CPL Section 70.102. Although defendant attempted to contest his designation as a persistent felony offender, the court interrupted to explain that it's only relevant if he's convicted and the prosecution files persistent papers, and then resumed jury selection. On the following day, defendant pleaded guilty to the indictment in exchange for the recommended sentence. In fact, based on his record, defendant was correct that he could not have been sentenced as a persistent felony offender if convicted at trial. Eventually, defense counsel realized his error. When the parties appeared in front of the same judge on July 24, 2018, defense counsel moved to withdraw defendant's plea on the ground of this mistake, noting that defendant pleaded guilty to avoid a potential life sentence. The prosecution consented to defense counsel's motion. Defendant then made another request to proceed pro se. Defendant: if I'm taking this plea back, I don't need defense counsel representing me. If I'm going to go to trial, that's what it's looking like. So I take my chances with a new attorney because this attorney is ineffective and I've got paperwork for you. The court: I understand what you're saying. So how long will it take you to hire a lawyer? Defendant: I would represent myself. The court: sorry? Defendant: I would like to represent myself. The court: you're going to represent yourself? Defendant: yes. The court: I'll deal with that. Defense counsel is on the case until you can hire another attorney. If you choose to go pro se at the time of trial, I'll entertain your application at that point, but defense counsel, you're still on the case. The court vacated defendant's guilty plea and adjourned the case for trial. On September 24, 2018, the day before jury selection was scheduled to begin, defense counsel made an application to be relieved, again to the same judge from prior proceedings. Defense counsel: Judge, I have to make an application to be relieved. I know I've made other applications in the past. I did a video conference with defendant on Friday. Not to belabor the point, but he did threaten to kill me during our video conference, so on those grounds, Judge, I'd ask to be relieved. The court: all right. Defense counsel: I know you're very familiar with this case. You've had the case for quite some time, sick. In fact, if memory served me correct, we picked a jury on this case before your client entered into a plea of guilty. We subsequently gave your client his plea back based upon your application, and I know that you're ready to proceed now. Passions do run high when a trial's about to start, and things are said, but your application to be relieved is most respectfully denied. I want to move this case, and move this case expeditiously, so your application is denied. The court subsequently addressed defendant directly and explained that it would give him the benefit of the doubt, that if he in any way, shape or form had threatened defense counsel, he didn't mean it. However, the next morning, the court restated defense counsel's request to be relieved based on defendant's threat, and it then took a statement on the record from a court officer who claimed that defendant had threatened him earlier that day. Based on the two reported threats, the court ordered defendant handcuffed during trial, but it did not revisit defense counsel's request to be relieved. Defendant proceeded to trial represented by defense counsel. The jury acquitted defendant of attempted murder, but it convicted him of all other offenses. The court sentenced defendant to 25 years incarceration and 5 years post-release supervision, the maximum legal sentence. On appeal, defendant argued, in part, that the court erred by denying without inquiry his unequivocal request to proceed pro se, and that the evidence at trial was legally insufficient to show that he caused the complainant to suffer a serious physical injury, which was a necessary element of 1 robbery count and 2 assault counts. The appellate division affirmed the judgment. The court held that the lower court did not violate defendant's right to self-representation, because his requests to proceed pro se, which were made in the context of his claim of dissatisfaction with counsel, were not unequivocal. The appellate division also concluded that defendant's legal sufficiency argument was unpreserved, and in any event, without merit. A judge of this court granted defendant leave to appeal. 2. Defendant renews his claims that Supreme Court violated his constitutional right to self-representation by refusing to entertain his unequivocal requests to proceed pro se, and that the evidence was legally insufficient to establish that he caused the complainant to suffer a serious physical injury. He requests a new trial or, should the court conclude that his right to self-representation was not violated, that his convictions of offenses that require proof of serious physical injury be reduced to lesser included offenses that lack this element. The prosecution counters, first, that defendant's requests to proceed pro se were equivocal when considered in broader context and did not require the court to make any inquiry, and that he abandoned his request by failing to raise it on the day of trial, as the court stated he could. Second, the prosecution argues that defendant's legal sufficiency argument is unpreserved and meritless. We conclude that the court violated defendant's right to self-representation when it denied, without the requisite inquiry, his unequivocal request to proceed pro se. Defendant's legal sufficiency argument is unpreserved. Thus, we remit this matter for a new trial on the offenses for which defendant was convicted. The right to self-representation embodies one of the most cherished ideals of our culture, the right of an individual to determine their own destiny. McIntyre. Both the United States Supreme Court and this court have recognized the right as constitutionally protected. See Ferretta v. California. Although not stated in the Sixth Amendment in so many words, the right to self-representation to make one's own defense personally is necessarily implied by the structure of the amendment. McIntyre. The New York State Constitution and Criminal Procedure Statute clearly recognize the right to proceed pro se. The court has long understood that defendants may assert their right to self-representation for a variety of reasons, including dissatisfaction with counsel. McIntyre. Other motivations are less virtuous, and a declaration to proceed pro se may be a means to delay the proceedings and obstruct the judicial process. In light of the manifold and conflicting principles permeating the assertion of a defendant's right to defend pro se, it is not absolute but subject to certain restrictions. Such limitations must be implemented in order to promote the orderly administration of justice and to prevent subsequent attack on a verdict claiming a denial of fundamental fairness. Under McIntyre's three-pronged test, a defendant may proceed pro se if 1. The request is unequivocal and timely asserted, 2. There has been a knowing and intelligent waiver of the right to counsel, and 3. The defendant has not engaged in conduct which would prevent the fair and orderly exposition of the issues. As it is uncontested that the court did not make the inquiry required by prong 2, the sole question on appeal is whether any of defendant's requests to proceed pro se were timely and unequivocal. 3. We conclude from the record that defendant made an unequivocal request to proceed pro se after he moved to withdraw his guilty plea on July 24, 2018. Defendant stated that he was taking his plea back and didn't need counsel, whom he believed was ineffective, to represent him at trial. He asserted that he would take his chances with a new attorney, and when the court asked how long defendant needed to hire one, defendant responded that he would represent himself. When the court appeared not to understand, defendant repeated that he would like to represent himself. The court then asked, "You're going to represent yourself?" Defendant did not mince words and responded, simply, "Yes." There is no other plausible reading of this colloquy than that defendant twice requested to represent himself, and in direct response to the court's question of whether he would represent himself at trial, answered in the simplest and most direct way with a single yes. The dissent's conclusion that defendant's statements were equivocal when placed in broader context, because they reflect his dissatisfaction with counsel and not a genuine interest in self-representation, is not only belied by the record, but also unsupported by our precedent. Indeed, the cases cited by the dissent are distinguishable, and none of them alter the straightforward rule from McIntyre that a court must inquire into a timely and unequivocal request to proceed pro se. In People v. Gillian, the defendant moved in writing for reassignment of counsel or, in the alternative, the opportunity to proceed pro se, after he previously informed the court that he wanted to proceed pro se based on dissatisfaction with defense counsel. The court granted the defendant's primary request and appointed new counsel. The defendant expressed no dissatisfaction with the appointment and remained silent thereafter. The court rejected the defendant's claim on appeal that his right to self-representation was violated, explaining that while the defendant's conditioning of his request for new counsel with a request for self-representation did not necessarily render the latter request equivocal, the defendant's initial requests to proceed pro se were made in the alternative. He sought to represent himself only because the court refused to replace the first assigned counsel who had displeased him. Critically, when the court granted the defendant's request and appointed new counsel, the defendant made no further request to proceed pro se, meaning the issue of self-representation was closed, with the defendant seemingly satisfied with that appointment. In contrast, defendant, in this case, did not ask to proceed pro se as an alternative to receiving new counsel, nor did he leverage his right of self-representation in an attempt to compel the court to appoint another lawyer. Instead, defendant made a standalone request to proceed pro se. People v. Laval also does not support the dissent's conclusion. The defendant in Laval had made repeated complaints against his two lawyers on the day of jury selection. The court determined that the defendant's concerns with defense counsel were based on a disagreement over trial strategy. When the defendant again requested dismissal of defense counsel, and that the court permit him to represent himself, he explained that he could not follow defense counsel's trial strategy and accordingly, "The only thing I see and that's my last option is to represent myself, not that I want to, I don't know anything about the law, but at least I have a chance to prove my innocence." In response to the court's warnings about the perils of self-representation, the defendant requested that the court consider appointing new lawyers if it was going to deny his request to proceed pro se. Thus, the defendant in Laval made clear that he did not wish to proceed pro se, and like the defendant in Gillian, his request was couched as a means to secure new counsel. The court considered relevant that the defendant gave the impression that he was not committed to self-representation, that he was understandably hesitant considering the daunting task of undertaking self-representation in a capital case, that his request was conditional to whether the court forced him to go along with the strategy of his attorneys, that he stated that he saw self-representation as his last option, and finally, when the defendant mentioned self-representation for the last time, he again couched it as a hypothetical, adding the request for new lawyers as an alternative. The Laval court contrasted the defendant's equivocal and hesitant statements about proceeding pro se with the following unequivocal statements made by a defendant in a separate case: "I will represent myself, and it's my intention now to go pro se. Before I wanted to have an attorney, but I can't afford a private attorney. That's why I'm going pro se," citing Williams v. Bartlett. As in that case, defendant here did not hesitate, use any equivocal language, or state anything comparable to "my last option is to represent myself, not that I want to." And when the court summarily denied defendant's request to proceed pro se, defendant did not resort to asking for new counsel as an alternative, nor does People v. Payton support the dissent's context rationale. The defendant in Payton made multiple requests for adjournments and other motions, which the court concluded overshadowed his request to proceed pro se. Accordingly, the defendant did not demonstrate an actual fixed intention and desire to proceed without professional assistance in his defense. In plain contrast, defendant made his request immediately after he moved to withdraw the guilty plea that he only made because of defense counsel's erroneous assumption about his persistent felony offender status, which defendant had contested, to no avail. Thus, defendant had reason to seek dismissal of defense counsel and rely on his own ability to present a defense at his upcoming trial. He communicated that desire clearly and succinctly. This appeal is also distinguishable from People v. Duarte. In that case, immediately after the court denied the defendant's request for counsel to be relieved, and just as the court commenced a pre-trial suppression hearing, defendant stated that he would love to go pro se. The court did not respond, and it instead asked the prosecution to clarify the scope of the hearing and call their first witness. To the extent that the court's lack of response indicated that it did not consider the defendant's statement sufficiently unequivocal, there was no such silence here. The court's substantive response to defendant showed that it believed he made an unequivocal request. After defendant twice asserted he wanted to represent himself, the court asked rhetorically, "You're going to represent yourself?" Defendant answered, "Yes." The court responded that it would deal with that and immediately denied defendant's request, instructed defense counsel to continue his representation, and informed defendant that it would not consider any other requests to proceed pro se until trial. Defendant's statement was a request to proceed pro se, and the court understood as much. This record belies the dissent's claim that the court did not view defendant's request as genuine. The court understood that defendant made an application that required resolution. Despite this recognition, the court's actions fell short of what the federal and state constitutions require. Once defendant invoked his right to self-representation, the court's duty was clear: ensure that defendant's waiver of counsel was made competently, intelligently, and voluntarily. McIntyre. We reject the prosecution's additional argument that defendant abandoned his request to proceed pro se when he did not make a new application on the morning of trial, months later, as the court instructed. McIntyre plainly requires only a single unequivocal and timely request to trigger the court's duty to inquire. Here, the court told defendant he could make another application at trial, which commenced months later. But waiting until the morning of trial would be too late for defendant to prepare his own defense, especially since the court required defense counsel to continue representation. Defendant's only option if he desired to make a new application would be to seek an adjournment and further prolong his nearly 2-year pre-trial incarceration, a request that the court signaled it would not be amenable to when, the day before, it summarily denied defense counsel's request to be relieved because it wanted to move the case expeditiously. As Justice Thurgood Marshall explained, unnecessary delay in considering a defendant's unequivocal request to proceed pro se fails to protect the right to self-representation. Delay in holding a hearing after the right to self-representation is unequivocally asserted undermines that right by forcing the accused to proceed with counsel in whom they have no confidence and whom they may distrust. For that reason, a post hoc effort to construe as subsequently ambiguous a clear assertion of a desire to proceed on one's own, contravenes the right. It encourages courts to leave a request pending, in the hope that the request will eventually be construed as ambiguous. Rawlerson v. Wainwright, Marshall, J., dissenting. Moreover, as this court noted in McIntyre, when a defendant makes a request to proceed pro se prior to the commencement of trial, the potential for obstruction and diversion is minimal, and a court may conduct a thorough inquiry, thereby averting delay and confusion. Put another way, the constitutional right to self-representation does not tolerate a court's unjustifiable delay in responding to a defendant's unequivocal request to proceed pro se. Lastly, we are unpersuaded by the prosecution's argument that the court properly considered defendant's request as inauthentic and merely a delay tactic, given the court's prior experience with defendant during other pretrial proceedings. It is true that when defendant made his first request to proceed pro se on June 4, 2018, the court believed he was playing games with the court. However, the court made no such statement in response to defendant's request on July 28, 2018, and instead dealt with it by rejecting the request and refusing to consider any other request until trial. The court had no authority to impose a requirement for repeated invocations of the right to self-representation before it would properly consider them. Nor may the court, as the prosecution argues, skip the inquiry entirely based on assumptions about a defendant's motive for making an unequivocal request. This position means that a court could decide, without inquiry, that a defendant's request to proceed pro se is equivocal because it is either not a knowing, voluntary, and intelligent waiver, or because a court assumes it is motivated by an intent to prevent the fair and orderly exposition of the issues. The McIntyre court rejected what is essentially this collapse of the three prongs of the analysis into one. Instead, where a court feels that the motion is a disingenuous attempt to subvert the overall purpose of the trial, as may well have been the case here, the proper procedure is to conduct a dispassionate inquiry into the pertinent factors. As in McIntyre, here the trial court denied the motion without eliciting the information which might have warranted denial of the motion. The court's failure to inquire into defendant's unequivocal request to proceed pro se violated his right to self-representation and, accordingly, defendant is entitled to a new trial. Defendant's additional claim that the evidence was legally insufficient to show that he caused the complainant to suffer serious physical injury, requiring reduction of several counts of conviction to lesser included offenses, isn't preserved. At trial, defense counsel only made a general and conclusory legal sufficiency argument that was not directed at this specific error, see People v. Gray, and the court had not previously rendered a ruling adverse to defendant on this issue, see People v. Finch. Having received an adverse ruling, the defendant did not specifically urge the same theory again in support of his motion to dismiss for insufficiency at trial. But he did not have to, once is enough. Because we order a new trial on other grounds, we need not consider defendant's related claim that defense counsel was ineffective for, among other reasons, failing to preserve defendant's legal sufficiency claim. Accordingly, the appellate division's order should be reversed and a new trial ordered. Order reversed and a new trial ordered. Opinion by Judge Rivera. Chief Judge Wilson and Judges Troutman and Halligan concur. Judge Singh's dissents and votes to affirm in an opinion, in which Judges Garcia and Canataro concur. Decided May 20, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.